Okay, we are on the record. Good morning. This is a case in front of the Public Service Commission of Maryland, captioned in the matter of the application of Columbia Gas of Maryland, Inc. for authority to increase rates and charges. This is case number 9644. My name is Kristen Lawrence. I'm the Public Utility Law Judge assigned to hear this matter. We'll start with appearances. Counsel for Columbia Gas of Maryland, please identify yourself and your client for the record.
Thank you, Your Honor. I'll start and introduce the others. I'm Carville Collins on behalf of Columbia Gas of Maryland, and with me today is Megan Moore and also Amy Harakis.
And for staff?
Your Honor, Peter Wolson appearing for the technical staff of the Public Service Commission. Also present from the Staff Counsel Division are attorneys Kenneth Albert and Catherine McErlin.
And Office of People's Counsel?
Your Honor, on behalf of the Office of People's Counsel, Frederick Hoover, and with me is Gary Alexander and William Fields.
Okay. Mr. Hoover, has Mr. Fields entered his appearance in the case?
No, I don't think he specifically has. He's just tuned into the hearing today.
Okay.
But does not intend to participate. So.
Okay. And Mr. Wolson has, I know Ms. McErlin has entered her appearance. How about Mr. Albert? Mr. Wolson, I muted you because you failed to mute yourself after you were finished, so you have to unmute yourself.
Yes, Mr. Albert's appearance was entered in the case docket.
Thank you. Okay, I think the way that we will proceed today is we will start with Columbia with any exhibits that Columbia would like to enter into the record, and then if Columbia would like to proffer any settlement terms that were reached, they may also do that. So I'll start with you, I guess, Mr. Collins.
Your Honor, on behalf of the Office of People's Counsel, we want to object to the consideration of the proposed settlement and the introduction into evidence of the joint settlement term sheet, as was noted in our letter yesterday. It is our view that...
Mr. Hoover, I received your letter. We're not even up to that point yet. Your objection is noted for the record. Thanks. Mr. Collins?
Thank you, Your Honor. We'll begin with, as you've instructed, with identifying, marking a number of exhibits. These were exhibits that were pre-marked in our case. After that, we propose to then introduce and mark the exhibits of the witnesses. We will start with the witnesses that you have indicated you would like to have questions for. I believe there's a total of 8 witnesses that you've listed, so we'll follow along in that progression. And then upon the conclusion of the discussion that we may have with any of those witnesses, we will then mark and move into the record the remaining testimonies and exhibits of the other witnesses in the case that you have indicated you do not have any questions for today. If there are any concerns or objections, please let me know, but that's our proposal.
Okay, proceed.
Thank you so much. And first, in order to facilitate a coherent numbering, Your Honor, you may recall that at our pre-hearing conference earlier this year, we had marked and moved into the record a first exhibit. This was the exhibit evidencing the affidavits and certificates of publication for the pre-hearing conference. I believe, if my memory is good, we marked that as Columbia Exhibit 1 to facilitate an orderly progression here. With your permission, we'd like to ask Your Honor to make a slight change in that numerical determination. We'd like to ask that that be labeled as Exhibit A and use an alphabetical one so that we can pick up with the numbering that we've used for the pre-marked exhibits in the case, starting with 1. So with your permission, we'd like to ask, if there's no objection from the parties, that Columbia Exhibit 1 be remarked as Columbia Exhibit A.
That's fine with me. Okay, proceed.
Thank you. Then turning to a group of exhibits that were pre-marked in the case. There's a total of 12 exhibits, exhibits 1 through 12, and there are various subparts to some of them. I'll go through that. And then there are also these same exhibits with the same numerics for that are also noted as supplemental, and a third group that is noted as rebuttal. So I'll start with the initial exhibits, 1 through 12. And by the way, for the convenience of the parties, Ms. Moore has sent to all of the parties in the case just a few minutes ago the current list that I'll be working from. So please feel free to follow along on that list. You will see a listing, and I hope that I'm gonna work off of that list and include each and every exhibit that is listed on that list, just so we're all on the same page. In that regard, there is Exhibit 1, Exhibit 2 with subparts A through G, Exhibit 3, Exhibit 4, Exhibit 5, Exhibit 6, Exhibit 7, Exhibit 8, Exhibit 9, Exhibit 10, Exhibit 11, parts A through F, Exhibit 12. So we'd like to ask for those exhibits to be marked in exact accordance with how they've been pre-marked in the case as exhibits 1 through 12. In addition, starting with Exhibit 1 supplemental, there are a series of supplemental exhibits, and that again is Exhibit 1, Exhibit 2, parts A through G, Exhibit 3 supplemental, Exhibit 4 supplemental, Exhibit 5 supplemental, Exhibit 6 supplemental, Exhibit 7 supplemental, Exhibit 8 supplemental, Exhibit 9 supplemental, Exhibit 10 supplemental, Exhibit 11 supplemental, and that includes subparts A through F, and Exhibit 12 supplemental. Again, we'd like those marked in accordance with how they've been pre-marked in the case, exhibits 1 through 12 supplemental. The last group is the rebuttal exhibits, and that it goes as follows. Again, these are pre-marked in the case. Exhibit 1 rebuttal, Exhibit 2 rebuttal, and that includes parts A through G, Exhibit 3 rebuttal, Exhibit 4 rebuttal, Exhibit 5 rebuttal, Exhibit 6 rebuttal, Exhibit 7 rebuttal, Exhibit 8 rebuttal, Exhibit 9 rebuttal, Exhibit 10 rebuttal, Exhibit 11 rebuttal, and that includes subparts A through F, and Exhibit 12 rebuttal. Again, we ask that those be marked exhibits 1 through 12 rebuttal as they have been pre-marked in the case. And if there are no objections, Your Honor, I would ask that all of these exhibits 1 through 12 in the 3 groups that I have identified be moved into the record.
Mr. Collins, I'm sorry, where is the rebuttal testimony?
The rebuttal testimony, Your Honor, we will be, we intend to provide that information and that testimony that will be, we will be doing that with each of the witnesses as the witnesses are identified, and I plan to do that next.
Okay. Unless there's any objection, the exhibits, I'm looking at what Ms. Moore just circulated this morning, and those exhibits 1 through 12, including the subparts, supplemental 1 through 12 with subparts, and then the rebuttal exhibits you identified 1 through 12, including subparts, are marked and entered into the record.
Thank you. And also, Your Honor, just for clarification, remember there was that third group of supplemental. So there was an original group, then a supplemental group, and then a rebuttal group, a total of 3 groups, each containing the 12 exhibits.
Yes, they've all been entered into the record at this point.
Thank you so much. What I next propose to do with your approval, Your Honor, is to mark Exhibit 13. That will be the first of the direct testimonies of one of the witnesses. And in fact, it's the first witness on your list, Mr. Tubbs. And so if you would like to proceed this way, we could have Mr. Tubbs introduce his testimony. I'd like to ask him to make a brief statement about the settlement and then make him available for questions from Your Honor.
Sounds good. So Exhibit 13, the direct testimony of Andrew S. Tubbs is pre-marked and now marked as Exhibit 13.
Thank you so much.
Does Mr. Tubbs know how to unmute himself, or do you need me to?
I got it, I think.
Okay.
If you could.
And so, Your Honor, I'm going to, with your permission, I'm just going to go ahead and run through the standard preliminary questions for Mr. Tubbs to offer his direct testimony. And then at the end of that, I'll ask that it be moved into the record, and then I'll ask him for his statement concerning the settlement. Would that be appropriate?
Yes.
Thank you. Mr. Tubbs, good morning.
Good morning.
Your Honor, is it appropriate at this point to let the court reporter swear in the witness, or shall we just proceed?
Actually, I have to do it. Mr. Tubbs, can you please raise your right hand? Do you swear or affirm under penalties of perjury that the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Now you can proceed.
Thank you, Your Honor. For the record, Mr. Tubbs, please state your employer and title.
My employer is Columbia Gas of Maryland. My title is the Vice President of External and Customer Affairs.
Thank you. And you have before you your direct testimony, in this case, dated May 15th.
I do.
Was this testimony prepared by you or under your supervision?
It was.
Any changes, corrections, or updates to the testimony?
No, I have no changes.
Is your testimony true and accurate to the best of your information, knowledge, and belief?
Yes, it is.
If you were giving this same testimony today, would your testimony be the same as when the testimony was originally filed?
Yes, it would.
Your Honor, thank you. I understand we've marked this as Columbia Exhibit 13. And if there are no objections, I would ask that Columbia Exhibit 13 be admitted into the record.
Seeing, hearing no objections, Columbia Exhibit 13 is admitted into the record.
And then just for the party's benefit, we'd like to engage in a very brief rejoinder in the nature of my asking Mr. Tubbs about the settlement to give an overview. And hopefully this also gives us a little bit of a framework and context for the proceedings today. So with that, let me ask Mr. Tubbs, would you please give a brief summary of the settlement and its terms that the parties have discussed and agreed to at this point?
Your Honor, Frederick Hoover, on behalf of the Office of People's Counsel, I want to renew my objection to the consideration of the settlement It is our position that we do not have a settlement in this case because we do not have a full, completed, signed settlement agreement. What we merely have is a term sheet that indicates some of the agreement that has been reached among the parties, but it does not represent a complete and authorized agreement amongst the parties to settle this case. And
I
so
believe that Mr. Collins is going to have Mr. Tubbs talk about the term sheet. Mr. Collins, it might be that Mr. Hoover is taking offense with your use of the term the settlement. If perhaps we could rephrase it and have Mr. Tubbs discuss the term sheet and the provisions thereof, I think we can all agree that that was all completely agreed to. Correct? So why don't you proceed under that, guys, please?
Well, Your Honor, if I may, we still have an objection to consideration of this matter in its entirety. I mean, our view is...
Mr. Hoover, I am not considering the settlement in its entirety. I'm considering the term sheet that was submitted to me and all parties agreed to.
But our position is that it's improper to consider just pieces of this settlement at this time. It is our view that the review should be...
And I disagree. I'm sorry. Your objection is overruled. It's noted for the record. It can be a standing objection to every question that discusses the term sheet. But we are going to move forward based on the term sheet that was submitted, and I was told everyone agreed to all of the terms. That is completely acceptable for questioning at this point, and we're going to proceed. Please, Mr. Collins.
Thank you, Your Honor. With that, then let me rephrase my question to Mr. Tubbs. Mr. Tubbs, would you please address the terms that are contained in the term sheet that was utilized and shared with the parties in our settlement discussions?
Yes, I will. As Mr. Collins indicated, we've reached a settlement in principle with the parties. A term sheet has been agreed to amongst the parties that resolves all issues in this case, including revenue requirement, revenue allocation, rate design, and other issues. Now, the parties are still reviewing certain components, but the term sheets, the principal terms, have all been settled. And this is, in our view, a solid term sheet as it follows a close examination of the company's filing, including 370 discovery questions posed by the parties, rounds of direct and rebuttal testimony in this case, as well as the individuals and parties involved in this case. Their counsel and subject matter experts have done a careful review, and based upon that review and discussions, we've reached a settlement in principle. That settlement in principle includes a authorized increase in base rates of $3.3 million annually. The company believes that this amount will enable us to continue to provide safe and reliable service to our customers. And we believe it also represents a reasonable compromise of the parties' positions in this proceeding. The amount of the increase falls within the range of outcomes bounded by the company's proposed increase, as well as the revenue requirements contained in the other parties' testimony in this case. While the parties here, while supporting their respective positions had we gone into litigation, recognize that not all of our positions would have been adopted had we litigated, and that there would have been some compromise or some reach in between. And we believe that this settlement of $3.3 million, allowing rates to go into effect on December 11th, 2020, does that. It also concludes that the system charge for residential customers would increase from $15.40 to $15.70 per month. I think a big component of the settlement for the parties deals with depreciation. The parties have agreed to use for purposes, the company has agreed to use FAS 143 methodology and the development of depreciation of rates in its next base rate case proceeding. This has been a significant issue of litigation in this case as well as prior cases. The company is agreeing to continue to use FAS 143 in its next base rate case while using the parameters that the company set forth in its direct testimony in this case, as well as unless there's a material change to those parameters, which the company would have to identify and then defend in its next case. In addition to use the FAS 143 method, the company will, we've agreed to use a discount factor consistent with credit adjusted return in its next base rate case. I think that this is a big component, as it is had been a highly contentious matter for some time. And I think that's a big move for, big part of the settlement here. In addition to those items, the company's request to include cloud-based assets and base rates of $96,513 has been accepted. Columbia has agreed to withdraw its request for commission authorization to defer post-test year expenses associated with the Picaro leak detection program. I'll talk a little bit more about that in a second. And for purposes of this proceeding, and that may in the future be initiated by Columbia, the Columbia will use a return on equity of 9.6% and an overall rate of return of 7.16%. The settlement also specifies an effective property tax rate, gross revenue, and conversion factors, and these factors will all be used by the company in future STRIDE filings. There's a couple other things I'd just like to highlight. The settlement also addresses, the settlement term sheet also addresses Columbia's proposal requesting authorization to defer on cross-bores, as well as the Picaro leak detection program, and also address the operational order charges revenue, which was a part of the company's filing. I think that the cross-bore program has been accepted as part of the settlement term sheet. The company is now going to be authorized to defer expenses up to $75,000 associated with the acceleration of its cross-bore program, which is in excess of the amount of $81,000 that is currently in the company's cost of service. The company will include the deferred amount of no more than $75,000 in a future base rate proceeding and amortize that amount over a 3-year period. In addition, the company will remove the authorization of the deferral from base rates once the deferral is fully amortized. Although the company has agreed to remove the deferral of costs associated with the Picaro leak system, the company will include any expenses incurred associated with this program and cost of service of its next base rate case. It's an important part of our safety management system, the Picaro leak system. So this is something the company is committed to, will continue to work on, but we agreed to remove the deferral request that we had in this case. Regarding the $202,992 associated with operational order charges revenue, the company in the settlement term sheet is agreeing that those revenues will not be included in the calculation of base rates. The company has agreed to credit those revenues through the commodity portion of the actual cost adjustment in its annual purchase gas adjustment proceeding over a 3-year period, beginning with the ACA that commences in December of 2020. The ACA rates ended December 2020, December 2021, and December of 2022 will each reflect a credit of $67,664 for the balance of accumulated OOCR revenues. In addition, the company agrees that these operational order credit revenues will be realized subsequent to March 30th, 2020, will be credited in the development of the commodity portion of the ACA rates. The inclusion of these revenues in the PGA proceeding ensures that these charges are timely passed back to customers in an annual proceeding. It also ensures that customers who are responsible for the charges do not receive any benefits from those charges, as inclusion of this revenue in a base rate proceeding reduces the overall revenue requirement for the company. So that reflects sort of the high-level summary of the settlement term sheet that we're working through and developing a joint petition for settlement in this case.
Thank you, Mr. Tubbs. And with that, Your Honor, Mr. Tubbs is available for any questions that you may have.
Thank you. Mr. Tubbs, if at any time I ask you a question and there's a witness that who's with us today who would better answer the question, please let me know, okay?
I will. Thank you.
In this case, the company requested an annual base rate revenue increase of $6.5 million, which was an overall increase of approximately 14.3%. As far as I can tell, the company proposed the same ROE in this case as in last year's case 9609 of 10.95%. The company also used the same method to calculate depreciation expense, that straight line method, and I believe replaced a similar mileage of pipe, although I can ask one of your witnesses. So, in broad brush general terms, can you explain to me why the higher increase sought this year of approximately 14% as compared to last year in case 9609 of approximately 7%?
I'm going to defer that question because I'm not sure that I will be able to give you a thorough answer. Yeah, I think, in large measure, I think that, the company continues to invest a significant amount of capital dollars into replacing infrastructure on its system. There are costs that vary from time to time, and there have been increases in costs in preparing and replacing pipe on our system. We continue to invest in new safety measures like the Picaro leak system, as well as the cross-bore program, and there are increases associated with those investments. But I think that's probably the high-level summary that I would give you.
Which witness or witnesses should I get more detail from?
I want to defer to Mr. Collins or Ms. Moore.
Your Honor, we will, in terms of the witnesses that you've called, we'll suggest one or more of those witnesses to be available to address that issue. I don't know that we have an answer at the moment, but over the course of going through the witnesses, I think we will make sure to address your question.
Okay, perhaps witness Krupa, perhaps witness Davidson. We'll see when we get there.
Very well, thank you.
Mr. Tubbs, I have a few more questions for you. Turning to the term sheet that you referenced, and I believe it contains a term that will likely be contained in any formal settlement agreement, that the rates that are agreed to will be effective with bills rendered as of December 11, 2020. My question is, does that mean bills sent on December 11, 2020 for gas service prior thereto, or does it only mean gas service on and after December 11, 2020?
Yeah, that's a good question, because our billing periods may not always match up. We have different batches, if you will, of bills. Probably ask our witness, is Melissa Bell on? No, she's not, but we can get you that answer when we expect that. I can get you that answer, Your Honor, during the course of today's hearing. Once you're done, I can do a quick message to our support team to get that answer for you.
Okay, thank you.
Yep.
And then you mentioned that the revenue requirement that's been agreed to is 3.3 million. Is that 3.3 million exactly? No change?
Yes, it is. I think that's right. Mr. Newcomb could clarify, but I think that's correct. 3.3 million. So
3.30000. No, you understand what I'm saying?
I do. I'm looking
at being rounded for purposes of. I'll get to him. He needs to be sworn in if he's going to testify.
Okay.
The effective date of the new rates is used when discussing rate case expenses, and I just wondered, is that not December 11, 2020? That might be a question for counsel, but
I believe that to Mr. Collins.
Okay, Mr. Collins, can you answer that now, or do you want to answer that later?
Your Honor, I think I may not have followed that question. Could you repeat, please?
Sure. In section C of the term sheet, at the end of that section, there's a phrase, the effective date of the new rates. And I just was trying to confirm that that was referring to December 11, 2020, the date referenced in paragraph A. What is the effective date of the new rates?
Subject to check, I believe it is December 11th, 2020. I will confirm that for you.
Your Honor, if I may.
Mr. Tubbs? Yes.
The revenue requirement will be exactly $3.3 million.
Thank you.
You're welcome.
And then, Mr. Tubbs, is Columbia Gas likely to file a make-whole proceeding in the near future?
It is unlikely, Your Honor, due to the company's the amount of investment that the company puts into its system for infrastructure replacement. The Commission's decision in prior proceedings to not permit Stride assets to be rolled into rate base in a make-whole proceeding. So for the company to be able to roll in Stride assets or Stride projects into rate base, it requires a base rate proceeding, not a make-whole.
You discussed the $202,992 in operational credit revenue.
Mm-hmm.
Why is that being credited over a 3-year period? Do you know?
I believe it's probably due to the amount of the credit, the $202,000, and but Ms. Moore, maybe she'll be able to offer some additional guidance here.
Okay, are you familiar with that revenue?
Yes.
Because I know that unfortunately Ms. Hassan is not available. I do know from her rebuttal testimony that that revenue occurred beginning in November of 2017. She testified that the operational order revenue of $202,992 occurred between November 2017 and March 2020. That's at page 7 of her rebuttal. I guess my question is, what has been happening with that revenue since November 2017?
I believe what reflect back to my. I believe this in our last the case 9609. This revenue was included in it's been included in the revenue requirement of the case. I think that's what in case 9609. The order charge revenue was included in revenue requirement. However, Columbia believes that these charges are better to be reflected in the ACA and given back to customers in that annual proceeding. But I think what you're asking me is how did that amount of $202,000 accumulate over that time period and not be reflected back? I think it's what's currently in the revenue requirement, where we pulled out those amounts and are going to get it back to customers through the ACA and the PGA over the next 3 years. And we believe that would be a more timely approach to returning those revenues. I hope that's responsive.
It is, except that I still don't know that I understand why something that occurred as far back as November 2017 is considered being timely credited back if it's going to take 3 years starting December 2020 to be credited back. But I'm not sure that's a question for you and more something maybe your counsel needs to address. And you don't need to do so now, Mr. Collins. And did you say that Mr. Newcomb is the proper witness to discuss the accounting related to the cross-border program, or are you somewhat familiar with the accounting related to that program?
I'm going to defer to Mr. Newcomb for the accounting. Your Honor, my understanding as well is the revenue requirement will start to be collected from customers for bills rendered as of December 11th. So the first billing cycle after December 11th that's when we'll start to collect the revenue requirement from our customers.
So conceivably, bills for service that was rendered prior to December 11, 2020.
I'm looking to Miss Moore here to confirm.
Ms. Moore, did you want to?
Good morning, Your Honor. So our intention with that language is to bills rendered. So we have certain customers that are on a 1-month lag, but also it is not supposed to be for, our intention is not to bill for service. I believe it should say service rendered on or after. So I am confirming that right now. So if you could come back to me, I'd appreciate that. Thank you.
Okay, Mr. Collins, I guess back to you with your exhibits and witnesses.
All right. Thank you, Your Honor. The next witness that I'd like to bring forward is Vince Reya. Vince, are you on and ready to proceed?
I am, Carvel.
Thank you.
Mr. Reya, can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed.
Thank you. Good morning, Mr. Reya.
Good morning.
For the record, please state your employer and title.
My employer is NiSource Corporate Services Company. My title is Director of Regulatory Finance and Economics.
And I'm going to ask you about all of your testimony, starting first with, do you have before you your direct testimony and attached appendices A through D and exhibits VVR-2 through VVR-13 dated May 15th. Do you have that?
Yes, I do.
And Your Honor, I'm going to propose that that direct testimony and those appendices and exhibits be marked as Columbia Exhibit 14.
So marked.
And then, Mr. Reya, do you also have your rebuttal testimony dated August 14th before you?
Yes, I do.
And Your Honor, I'd ask that that be marked as Columbia Exhibit 15.
So marked.
Mr. Reya, was this testimony prepared by you or under your supervision?
Yes, it was.
And do you have any changes, corrections, or updates to the testimony and or the exhibits specifically with regard to VVR1?
Yes, I do. In the process of filing direct testimony, it was determined that we would remove the reference in my direct testimony to VVR1. We would start my exhibits with VVR2, but inadvertently, the appendices to my testimony, specifically appendices A through D, continued to maintain the reference to exhibit VVR1, which should have been removed.
Thank you for that clarification. Is your testimony, both the direct and rebuttal, is it true and accurate to the best of your information, knowledge, and belief?
Yes, it is.
If you were giving the same testimony today, would your testimony be the same as when the testimony was originally filed?
Yes, it would.
Your Honor, then with that, if there are no objections, I would ask that Columbia Exhibits 14 and 15 be admitted into the record.
I see no objections and I'm hearing no objections. Columbia Exhibits 14 and 15 will be entered into the record.
Thank you, Your Honor. Your Honor, Mr. Reya is available for any questions you may have.
Mr. Reya, you testified that in view of the recent events in the U.S. capital markets, that you believe that OPC and staff failed to properly incorporate expectational inputs into their cost of equity evaluations. Those expectational inputs include reputable interest rate forecasts. Correct?
That is correct.
And in your rebuttal testimony, specifically, you cited prominent economists for the opinion that as the U.S. economy continues to recover from the COVID-19 crisis, long-term interest rates will continue to trend gradually higher. Do you recall that testimony?
Yes, I do.
In your opinion, is the U.S. economy already recovering from the COVID-19 crisis?
I think that it is. I think that we saw in Q2 2020 a significant decline in U.S. real GDP. I think the measurement was somewhere in the range of a negative 30% or so, and expectations are for Q3 2020, we expect to see a significant bounce up in real GDP. So I think it will be a rather gradual process, but I do think that we'll see a lot of market prognosticators are saying right now that we do expect to see a significant bump up in economic activity in the third quarter of the year.
Is there any possibility of further negative effects of the COVID-19 crisis?
Well, I think to the extent that we do not see positive developments with regard to therapeutics and ultimately with regard to a vaccine, we could take a few steps backward. But I think right now, I think all indications are that the vaccine process is progressing fairly well. And as a result of that, I don't really anticipate any steps backwards in the foreseeable future here.
Okay, but you testified that it would be a gradual process. Do you have an idea of how gradual? Are we talking years?
Well, I think that when you look at the blue chip economic forecast, which again I view as a very reputable publication because it does survey as many as 40 leading economists in the US and Canada, that we are expecting to see those increases over the next 2 or 3 years. When you look out the forecast horizon, although, you know, if you went back 6 months or 12 months ago and you looked at the blue chip financial forecast, they'd be a bit more robust than they are right now. But as per what I've provided in rebuttal, you do see that we are expecting a fairly decent increase in long-term interest rates over the next couple of years.
You said that was 2 to 3?
Yes, Your Honor.
So we're not expecting a long-term recession?
I think the view is right now that that's probably not in the cards. I think there is a wild card that is the U.S. presidential election. The potential for a contested presidential election could create some issues to the extent that the election in November becomes contested. But aside from any issues in that regard, I just don't see that happening over the next couple of years.
That's all I have for this witness, Mr. Collins.
Thank you, Your Honor. The next witness in our progression would be Mr. Robert Kitchell. Mr. Kitchell, are you ready to proceed?
Yes, I am.
Mr. Kitchell, can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Collins?
Thank you, Your Honor. Good morning, Mr. Kitchell.
Good morning.
The record, would you please state your employer and title?
I am employed by Columbia Gas of Maryland as Vice President of Construction Services. I also serve in the capacity for Columbia Gas of Pennsylvania in the same role.
And do you have before you your direct testimony dated May 15th?
I do.
And was this testimony prepared by you or under your supervision?
It was.
Do you have any changes, corrections, or updates to the testimony?
No changes.
Is your testimony true and accurate to the best of your information, knowledge, and belief?
Yes, it is.
If you were giving this same testimony today, would your testimony be the same as when the testimony was originally filed?
Yes, it would.
Your Honor, I would ask that the direct testimony of Mr. Kitchell be marked as Columbia Exhibit 16.
So marked.
And if there are no objections, I would ask that Columbia Exhibit 16 be admitted into the record.
Do I hear an objection? No. Exhibit 16 is entered into the record.
Thank you. Your Honor, Mr. Kitchell is available for any questions you may have.
Mr. Kitchell, I believe at least pursuant to the STRIDE program, the company replaced about the same miles of pipe as it did last year. Is that correct?
Yes.
And do you know if the costs incurred during the test year in this case are comparable to the costs incurred during the test year in case 9609?
Just a second. Your Honor, I do not have the case numbers here, so are you comparing 2019 to 2018 costs?
I'm comparing the costs basically in last year's rate case in 2019 to this year's case. I guess, in other words, in this year, did the company incur any unusual costs in replacing the same mileage of pipe as it did last year?
Not unusual costs. This is the first year I was involved in the rate case for Columbia, Maryland.
Okay, then you might not be able to answer the question.
Yeah, I may need to defer to somebody on my team for that.
Okay, do you have any thoughts on who that might be? Mr. Kitchell, do you know who might? I'm still trying to get at the question that I asked Mr. Tubbs about why the larger increase this year from last year. And he mentioned capital costs and various projects, but it doesn't sound as though you're able to give a better answer.
At this time, no, I am not.
Okay. Mr. Collins, back to you.
Your Honor, I anticipate that another witness who will appear today will be available to address that specific question concerning 2019 versus 2020. Perhaps it's Mr. Davidson, but we will, before we're done, we will have that question addressed.
Okay, and as you know, we're likely to continue this hearing to next week on the 18th. So the extent that you need another day to present a witness, we can do that. Otherwise, please proceed your next exhibit or witness.
Thank you. Your Honor, the next witness is Kellene Krupa. Ms. Krupa, are you ready to proceed?
I am.
Ms. Krupa, can you raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed.
Thank you, Your Honor. Good morning, Ms. Krupa.
Morning.
Let's start with, for the record, please state your employer and title.
My employer is NiSource Inc., and I'm manager of regulatory.
And do you have before you your testimony? Let me start first with the direct testimony of yours and attachment KMK-1 dated May 15th. Do you have that?
Yes, I do.
And Your Honor, I would like to ask for Ms. Krupa's direct testimony and attachment to be marked as Columbia Exhibit 17.
So marked.
And then, Ms. Krupa, do you have also before you your rebuttal testimony dated August 14?
I do.
And Your Honor, I would ask that Ms. Krupa's rebuttal testimony be marked as Columbia Exhibit 18.
So marked.
Thank you. And Ms. Krupa, was all of this testimony prepared by you or under your supervision?
Yes.
Do you have any changes, corrections, or updates to the testimony?
No.
Is your testimony true and accurate to the best of your information, knowledge, and belief?
Yes.
if you were giving this same testimony today, would your testimony be the same as when the testimony was originally filed?
Yes.
Your Honor, if there are no objections, I would ask that Columbia Exhibits 17 and 18 be admitted into the record.
Hearing no objections, Columbia 17 and 18 are admitted into the record.
Thank you, Your Honor. The witness is available for any questions you may have.
Ms. Krupa, it looks like the company proposed 2 adjustments in the area of safety and reliability. And then those were updated with supplemental exhibits. So for the 2 months, well, if initially there was an adjustment to rate base of $6,120,000 on a terminal basis, and then a second adjustment, which was to include the 2 months of June and July 2020. And then when it was updated, that amount was $3.95 million, which represents the estimated plant and reserve activity for balances for June and July. Do you know, has there been an update to those figures, or are those figures about the same?
So, Your Honor, are you referring to what's the numbers that are in my rebuttal testimony exhibit 8?
Yes.
Column 4 and 5?
Yes.
Yes, those are still accurate.
Okay. Do you know how these amounts compare with similar adjustments that were proposed last year in case number 9609?
I do not at this point, but that's something I can get for you.
Okay, and then you'll get back to me.
Yes.
Great. Thank you. Back to you, Mr. Collins.
Thank you, Your Honor. I'm going to ask Ms. Moore to take the next group of witnesses who are on Your Honor's list of witnesses for whom you will have questions. Megan, would you like to proceed?
Yes, Carvel, thank you. Your Honor, if I may try and shed some light on some of your prior questions. I know there were a few, but I at least want to get back to the bills rendered versus service rendered. So the reason the answer is yes. By having bills rendered after December 11th in the term sheet, that means that service prior to that would be billed at the new rates. And the reason for that is so that the company does not have to prorate. If it was service rendered, we will be prorating in the middle of billing cycles. So that is the cleanest way for us to implement the billing and not incur extra costs for the proration. So I hope that answers your question on that.
Thank you.
Yes. And back to the operational order charge revenue question, I will try to shed some light on that. So the reason why the balance was $202,000, it was from it was for revenue that came in from 2017 till I think sometime in 2020. It was recognized on the books in this test year, and that's why the full 202 came in. Now, where was it, I believe, was one of your questions. It was the company's practice to defer these costs and then bring them in on a PGA time frame, which doesn't mirror our test year and doesn't mirror our calendar year. When your proposed order came out and then it was affirmed by the commission in December of 2019, that is when we had, it was in a deferred account, and then it was recognized as revenue and hit the books based on your order, which was that these revenues should, based on your order with regard to these revenues from that case. So I hope that sheds some light there. I'll pause in the event you have a follow-up to what I said.
Well, what about answering the question why it's being spread out over 3 years?
The 3 years. So it was the company's original position to have the application of these revenues be prospective, as in after, the next group that we would collect. So that was our initial position. It was staff that came back. We worked with them for weeks on this issue, and their compromise position was, hey, look, we think that, and Peter, I'm sorry, I will be articulating what I think your position is, and please feel free to jump in. So I believe staff.
Yeah, I guess I don't really want to know about the settlement negotiations so much as what's your position on why it makes sense to spread it out over 3 years?
That was the compromise, and by dividing it in 3, it is the costs are more akin to what we're used to getting every year. Does that make sense? So what we would bring in from those revenues, 202 was a large amount because it was about a 3 years worth of an amount. So by spreading it over 3 years, it would be similar to 1 year's worth.
Your Honor, if I might add something out of turn.
Yes.
I believe staff looked at it that this money was accrued over 3 years, and so that as a compromise position to allow it to be dispersed over 3 years would be acceptable. But
Thank you. Ms. Moore, did you have any other things you were trying to clarify at this time, or is that it?
Yes, Your Honor, I have 1 or 2 more clarifications. So you were asking Mr. Kitchell about costs for the STRIDE program, I believe, versus 2019 versus 2020. We are seeing increased costs in 2020. And that takes me back to why this case was a larger ask than last year's case. And most of that is related to increased capital costs.
That were approved in the STRIDE case?
Yes, so there is a, as you know, Your Honor, there is a cap to, there's a STRIDE cap, but there's also what we agreed to in the settlement in that case for the costs that would go into STRIDE. So they're not all capital costs related to STRIDE. We have a certain threshold that we work within for the STRIDE budget, and everything else is outside of that, and is one of the reasons we come in each year, and those costs are looked at in the context of our base rate cases.
Anything else?
I believe that's it. I hope I shed some light on your questions.
Your Honor, if I may.
Who's speaking?
This is Andy Tubbs.
Okay.
I apologize. So confirming now, but looking at the Columbia Gas of Maryland comes in on an annual basis because of the issue I mentioned before regarding rolling in STRIDE assets in a make-whole proceeding. And looking over the history of our cases, in 2016, Columbia Gas of Maryland filed for $6.5 million. In 2017, we filed for $6 million. In 2018, it was $6 million. 2019 was the dip you've identified, down to $3.7 million. In 2020, we're back up to 6.5. The intervening activity there was the tax reform bill. And so I'm confirming, but I do believe that we probably saw a decrease in 2019 related to the flow back of the tax credits to customers. But historically, we're right around the $6 million to $6.5 million request that we have here today in this case. But I wanted to kind of get that sort of backdrop to you. I'll confirm with you, but I wanted to provide a little bit more light here as we're in this hearing this morning.
Thank you. Are we with Mr. Collins or Ms. Moore on the next witness?
I'm going to let Ms. Moore introduce the next witness and testimony and exhibits.
Okay. Thank you, Your Honor. I am back to the witnesses here. Okay, we are going to go with Mr. Spanos. Mr. Spanos, good morning.
Good morning.
For the record, can you please state your name, employer, and title?
My name is John J. Spanos. My employer is Gannett Fleming Valuation and Rate Consultants, LLC, and my title is President.
Thank you, Mr. Spanos. Do you have before you your direct and rebuttal testimonies in this case, along with the corresponding exhibits that were attached to your testimonies?
Yes, I do.
Okay. Was your testimony prepared by you or under your direct supervision?
Yes, it was.
Do you have any changes, corrections, or updates to your testimonies?
No, I do not.
Okay. Are your testimonies true and accurate to the best of your information, knowledge, and belief?
Yes, they are.
If you were giving the same testimonies today, would your testimonies be the same as when they were originally filed?
Yes, they would.
Your Honor, I would ask that the direct testimony of John Spanos and attached exhibits JJS 1, JJS 2, and JJS 3 filed May 15th be marked as Columbia Exhibit 19.
So marked.
And Your Honor, if there are no objections, I would ask that Columbia Exhibit 19 be admitted into the record.
Hearing no objections, Exhibit 19 is entered.
And Your Honor, Mr. Spanos is available for your questions.
Did you want to enter Exhibit 20, Ms. Moore?
Yes, I do. Thank you very much, Your Honor. Also,
The rebuttal testimony, I believe, is marked as Exhibit 20.
Yes, the rebuttal testimony of Mr. Spanos, along with corresponding attachments A through D, I'd like to mark that as Exhibit 20.
So marked.
And Your Honor, pending any objections, I would ask that Exhibit 20 be admitted into the record.
Hearing no objections, Columbia Exhibits 19 and 20 are admitted into the record.
Thank you, Your Honor, for your patience. And now Mr. Spanos is available for your questions.
Okay, is Mr. Spanos? I heard him. I don't see him. Mr. Spanos, are you on the line?
I am here, yes.
Okay. Wherever you are, please raise your right hand. Do you swear or affirm under penalties of perjury the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Your rebuttal testimony at page 28, you testified that the credit-adjusted risk-free rate used by the company for asset retirement obligations is 3.6%. Do you recall that testimony?
I'm going to it now. Just 1 minute, please.
Page 28 of rebuttal.
Yes. The reference, and that was not the company's position. It was part of the discussion that I was referencing as to what the appropriate risk-free value would be under the criteria that in that particular section. So I'm not sure that's exactly the position that I was writing about, but I wanted to make sure I understood your question specifically.
Well, was the credit-adjusted risk-free rate used by the company for asset retirement obligations 3.6%? I believe that was over the last 30 years.
Yes, that is. Sorry, I misunderstood what your question was.
And then you went on to testify that if Mr. Patterson's intent, you say were, to actually use a credit-adjusted risk-free rate, he should use a rate of 3.6%. Correct? That's your testimony?
That is correct.
Okay, Mr. Tubbs, I don't know if you were on the line when Mr. Tubbs testified, but he testified that the depreciation provisions in the term sheet were significant in this particular case. And Section G of the term sheet is depreciation. One of the items is that the company agrees or agreed to use an appropriate discount factor consistent with a credit-adjusted return in its next base rate case. So, Mr. Spanos, assuming you are still the company's depreciation consultant next year, if it files a rate case, what discount factor will you be using?
Well, first, my position was to utilize the net salvage, the traditional net salvage approach. However, given the situation and the agreement, if we're in the same position next year, I think it's most appropriate to have something closer to 3.6%. However, the agreement we have in the settlement is 6.1%. So unless there is the information that we have at that time creates a reason to change that position considerably, then we would maintain the risk-adjusted rate of the 6.1 if that's what is viewed to be reasonable.
Viewed by whom?
Well, I think that's part of the analysis that the company does, and then when I'm involved, we review that percentage. So Columbia would be looking at that information to determine whether it is still a reasonable percentage, and would maintain that position if they feel that's still reasonable. So I believe Columbia would be the lead as far as my involvement would be going forward.
Ms. Moore, can I ask you a question?
Yes, Your Honor. Thank you.
And tell me if I should direct this to Mr. Tubbs. But in the depreciation section of the term sheet, well, first, if under section F, other proceedings, Mr. Spanos referred to subsection 5. Depreciation rates by gas plant account will be those presented by the company in its direct testimony in case number 9644, revised to reflect the use of the SFAS 143 method for net salvage and applying a 6.1% discount rate, and are set forth in Appendix C here too. Then in section G, which is entitled depreciation, about halfway down, the sentence I was asking Mr. Spanos about is, the company agrees to use an appropriate discount factor consistent with a credit-adjusted return in its next base rate case. Mr. Spanos seemed to be testifying that that appropriate discount factor based on this settlement will be 6.1%. Do you care to elaborate?
Yes, I would like to clarify, Your Honor. We came to the agreement on the 6.1% discount rate, discount factor in this case as a compromise between the parties. It is our intention, I believe, or at least it was the company views Part G, the paragraph on depreciation, as allowing us to use what we would feel is an appropriate discount factor close to what whatever we think whatever we put forth as a reasonable credit adjusted or an appropriate credit adjusted risk-free rate. John's testimony, I believe, in this case had something around 3.6%. I just want to clarify that the company's position is not that 6.1 is the risk-free credit adjusted rate, but it would be more something akin to 3.6. And John, and I can let John speak to that as the subject matter expert, if Your Honor would be okay with that.
I think that you've clarified.
Okay.
That's all I have for that witness, and he can be excused, Ms. Moore, as he's not a company witness.
Thank you, Your Honor. So you would be okay with him signing off?
Yes.
Okay. Thank you, John.
Thank you. Thank you very much.
Thank you.
Your Honor, if I may, before I go to witness Newcomb, witness Krupa has some answers to your questions regarding safety and reliability in 19 verses 20.
Okay.
Thank you. So your question was, how did 2019 compare to 2020, Your Honor, correct?
Yes.
So 2020 is actually less than 2019. However, we have to note that the rate base cuts are different dates. So in 2019, The safety and reliability reach was July and August, where in 2020 it's June and July.
And that would account for the difference, you think?
I believe so.
Okay. Is that all you cared to add?
Yes. Thank you, Your Honor.
Thank you. Thank you. Ms. Moore?
Thank you, Your Honor. Next, the company would like to call witness Jeffrey Newcomb. Good afternoon, Mr. Newcomb.
Good afternoon.
For the record, please. Oh, I'm sorry, Your Honor. Please go proceed.
Well, what were you going to say?
I was going to say, are you going to swear him in now? Last time.
Yes, I will swear him in. I just need to
Thank you.
I just need to locate him.
He's in the middle of my screen. I don't know if that helps you.
Is he? No.
Jay.
Oh, I see you now. Sorry, Mr. Newcomb. Can you raise your right hand?
Yes.
Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed.
Thank you, Your Honor. Mr. Newcomb, for the record, can you please state your full name, your employer, and your title?
Yes. Jeffrey D. Newcomb. I'm employed by NiSource. My title is Manager of Regulatory Rate Case.
Mr. Newcomb, do you have before you your direct testimony, your supplemental testimony, your rebuttal testimony, and the corresponding attachments to those testimonies?
I do.
Were the testimonies prepared by you or under your direct supervision?
Yes, they were.
Mr. Newcomb, do you have any updates or changes to your testimony?
Yes. On page 16 of my rebuttal testimony, I make reference to attachment JDN-1R, where I provide actual rate case expenses and associated support through July 31st, 2020. At this time, I'd like to provide an update of actual rate case expenses through August 31st, 2020, and that amount is $38,893.
Thank you, Mr. Newcomb. And will you be filing any updated exhibits or invoices next week to support the updated amount?
Yes, I will, including any additional actual costs incurred through the date that we submit our joint settlement.
Thank you, Mr. Newcomb. With that change, are your testimonies true and accurate to the best of your information, knowledge, and belief?
Yes, they are.
If you were giving these testimonies today, would your testimonies be the same as when they were originally filed?
Yes, they would.
Your Honor, I would ask that the testimony and corresponding attachments, direct testimony and corresponding attachments JDN 1 and JDN 2 filed May 15th be marked as Exhibit 21.
So marked.
I would also ask that supplemental testimony of Mr. Newcomb filed July 1st be marked as Exhibit 22.
So marked.
And I would ask that the rebuttal testimony of Mr. Newcomb with attachments JDN 1R, JDN 2R, and JDN 3R be marked as Exhibit 23.
So marked.
And Your Honor, if there are no objections, I would ask that Columbia Exhibits 21, 22, and 23 be admitted into the record.
Hearing no objection, Columbia's Exhibits 21, 22, and 23 are entered into the record.
Thank you, Your Honor. Mr. Newcomb is available for your questions.
Okay, Ms. Moore, do you know when you expect to file those updated case expenses that he referenced?
Yes, Judge Lawrence, as you recall from the procedural, the pre-hearing conference, we will be filing those and providing them service of those by Wednesday, the 16th.
And what he referenced just now, has that been shared with the parties, or you won't share anything until the 16th?
I would hope to share it as soon as we could, but it will definitely be by the 16th. We can share what we have as of 8/31, or we can wait to include the expenses incurred this week.
Okay, I seem to recall from the pre-hearing conference, the hope was that this issue wouldn't need to be addressed at the subsequent hearing. Is that your understanding?
If the parties, I will have the witness available if the parties so need, Mr. Newcomb. But hopefully we're hoping to provide the adequate support in the form of invoices so that it wouldn't be needed on Friday.
Okay. Mr. Newcomb? Mr.
Yes.
Newcomb, hi. Do you know why the company included as a provision on the term sheet that the cloud-based assets in rate base of $96,513 are accepted? What's the import of that amount being called out when no other items or adjustments are called out?
That is an item of rate base, which would probably be best addressed by witness Krupa.
Mr. Tubbs, I believe, said you might be able to talk about the accounting related to the cross-bore program. That's you?
Yes, I can.
Okay. It's actually Mr. Davidson's testimony that stated, in conjunction with efforts to reduce risk on the system, Columbia is requesting deferral of $84,000 of costs related to two initiatives, the cross-bore remediation program and the Picaro leak detection program. These costs are not included in either Columbia's existing rates or the rates proposed in this proceeding. Do you understand that testimony?
Yes, I believe I do.
Okay, so if the costs are not included in the rates proposed in this proceeding, why are they being discussed in testimony in this case?
So the company is seeking to accelerate the program, so we will be incurring additional O&M costs, which are currently not funded.
So Mr. Davidson's testimony that discussed that these costs are not included in the rates proposed referred to only the acceleration costs?
Correct. The deferral up to 75,000. That's in addition to the amount that we have already included in our current proceeding.
So the 84,000 is all acceleration costs.
Just the 75. Picaro is a new program, so that it's not an acceleration, but it is the starting of a new program for leak detection.
Okay, do you know, or is Mr. Davidson the appropriate witness, how much has been spent on the program, and I'm sorry, the cross-bore remediation program? How much is in the cost of service in this case? Do you know? Not related to acceleration, but already spent.
Yes, I do have that amount. If 1 second, please. The current amount in the cost of service is $81,071 of O&M.
Okay, when did the company begin this program?
That question I would have to defer to witness Davidson.
Okay, so the company has already incurred $81,071 during the test year, and then when did it begin to accelerate the program?
We're seeking to accelerate the program in 2021.
Mr. Collins, are you still with us?
Yes, Your Honor.
Do you want to address this issue now, or do you want to address it at the end? I don't understand why or how I can consider a term that doesn't relate to the current rate case. Do you want to think about it, and we can talk about it at the end?
Yes, we'll discuss on a sidebar while this is going forward, and we will get back to you today.
Or if you need to take a break, you let me know.
Thank you so much.
Then, Mr. Newcomb, since you're the accounting person, though, why would $75,000 be amortized over a 3-year period? Does that make sense from an accounting perspective?
That was just a term based off of settlement that was a reasonable period to spread that increased cost of $75,000 to be recovered from ratepayers. So rather than hitting them with all $75,000 in 1 year, we thought it was more reasonable to spread that increased cost of $75,000 over 3 years.
In your professional opinion, does amortizing $75,000 over 3 years make sense, or does it cost more?
It makes sense, yes.
Did you indicate witness Krupa should answer one of the questions I asked you?
Yes, I don't recall the specific question. I think it was related to the cloud computing in rate base.
Okay. Can you talk to me about rate case expenses?
Yes.
Okay. Do you understand how they are being proposed to be treated?
Yes, we're proposing to amortize over 1 year.
Beginning December 11, 2020.
Correct.
So the entire amount of rate case expenses in this case would fall in potentially next year's rate case. Is that correct?
Any amount incurred after we submit actual rate case expense through the date of our joint settlement, submission of our joint settlement.
That's not what I'm asking. The rate
Okay.
case expenses in this case.
Yes.
Do you know the total amount approximately?
Yes, as I stated, through August 31st, 2020, actual rate case expense is $38,893.
Okay, I didn't know if that was the additional amount, or that's the new total.
That's the new total, correct?
In this case. Okay, but the term sheet indicates that that amount will be amortized starting December 11th, 2020. Correct?
Correct, Your Honor.
So when will the company actually collect that amount?
As we build new rates.
Okay. And is that any different from how that was proposed to be treated in this case by any of the parties?
No, that is not.
Okay, thank you. Mr. Collins, are you okay if I go back to witness Krupa?
Yes, Your Honor, that would be.
Okay, Ms. Krupa, hello again. You're still under oath. Mr. Newcomb indicated that you might be able to tell me why the cloud-based computing amount is called out as a provision on the term sheet when other adjustments are not.
Yeah, so cloud-based assets, there was an accounting change per FERC guidance that was issued on 12/20/2019. So prior to that date, it was being, you could see it in a 165 account. And per FERC in December, they switched it to going into plant. So like the 101s, the 107 account. And so our accounting made the change in March. So I believe that is the reason why it was called out on that term sheet.
Okay, no party opposed or proposed that that amount be removed from rate base, correct?
I don't believe so.
Okay, Ms. Moore, are we still with you?
Yes, Your Honor. We will go to our last witness, if that is okay with you.
Yes.
Okay. The company calls Michael Davidson.
Mr. Davidson,
Yes.
can you raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Please proceed.
Thank you, Your Honor. Good morning, Mr. Davidson.
Good morning.
For the record, can you please state your full name, your employer, and your title?
Yes, Michael J. Davidson. I'm employed by Columbia Gas of Maryland as General Manager and Vice President of Operations. And as with Mr. Kitchell, I have these same responsibilities for Columbia Gas of Pennsylvania.
Thank you. Do you have before you your direct testimony in this case, filed May 15th? Great. Was this testimony prepared by you or under your direct supervision?
Yes.
Do you have any changes, corrections, or updates to it?
No.
Is your testimony true and accurate to the best of your information, knowledge, and belief?
Yes.
If you were giving this same testimony today, would it be the same as when it was originally filed?
Yes.
Your Honor, I would ask that Mr. Davidson's direct testimony filed May 15th be marked as Exhibit 24.
So marked.
Excuse me. And Your Honor, if there are no objections, I would ask that Columbia Exhibit 24 be admitted into the record.
Hearing no objections, Columbia Exhibit 24 is admitted into the record.
Thank you, Your Honor. Mr. Davidson is available for your questions.
Mr. Davidson?
Good morning.
Hi. I understand from your testimony in this case that the company is proposing to employ the Picaro platform leak survey system in 2021. Is that correct?
That is correct.
Has the company incurred any expenses related to the Picaro leak survey system program in this, the test case or test year in this case?
Not to my knowledge.
Do you understand why it was part of this rate case?
I do.
Can you explain?
Yes, the system is an advanced leak detection system that's been introduced into the industry over the last few years. Columbia has looked at this technology and has made efforts to employ it across its distribution systems. Again, this is a system that really is being looked at across NiSource as a whole, and leveraging its scale to make the capital investments needed to implement this system. The benefits of the system, Your Honor, is that what you would like to hear also?
No. Actually, I guess at this point it's a question for counsel, because again, you testified that the company has not incurred any expenses related to this program in the test year in this case, correct?
That's correct.
You're not seeking to recover any costs related to the program in the rate case in this?
No.
This rate case, right? Okay, thank you. No, that's all I have for this witness. Back to you, Ms. Moore.
Thank you, Your Honor. And if I may speak a bit to the deferral provision of the settlement term, or just the term sheet.
As you wish.
Thank you. So if I understand your question correctly, it is how can you rule on the inclusion of those costs because they weren't actually incurred in the test year?
That's part of it. I guess it goes even deeper than that, although I'm not, as I told Mr. Hoover, considering the entirety of the settlement today. A question for the future might be how I might consider a settlement that contains a term that doesn't have anything to do with this rate case.
Understood. I hope that I can shed some light. So I think that it is important for, this term is important for the company, and we hope that what you will be opining on is the actual deferral mechanism, because in order for us to defer these costs from an accounting perspective, we need that in an order because we currently don't have costs budgeted for an amount over what's included in the cost of service.
Okay, I'll let other counsel address the issue when they feel it's appropriate.
Thank you.
Do you have anything further at this point?
At this point, if you have no further questions, I'd like to finish the rest of our exhibits.
Yes, please.
Sure. Just one moment. Okay. Your Honor, I would ask that the direct testimony of Shirley Bardis Hassan and her corresponding attachments, SBH 1, 2, and 3, filed May 15th, be marked as Exhibit 25.
So marked.
Also, Your Honor, I would ask that the rebuttal testimony of Ms. Bardis Hassan and attachments SBH 1R and SBH 2R, filed August 14th, be marked as Exhibit 26.
So marked.
And Your Honor, I would ask that, pending any objections, Columbia Exhibits 25 and 26 be admitted into the record.
Hearing no objection, Columbia Exhibits 25 and 26 are admitted into the record.
Thank you, Your Honor. Next, I would ask that the direct testimony of Jennifer Harding, filed May 15th, be marked as Exhibit 27.
So marked.
And Your Honor, I would ask that, pending any objections, Exhibit 27 be admitted into the record.
Exhibit 27 is admitted.
Thank you. Next, I would ask that the direct testimony of Joe Ferry and attachments JPF 1 through 4, filed May 15th, be marked as Exhibit 28.
So marked.
And Your Honor, if there are no objections, I would ask that Columbia Exhibit 28 be admitted into the record.
Columbia Exhibit 28 is admitted.
Next, I would ask that the direct testimony of Judith Siegler, filed May 15th, be marked as Exhibit 29.
So marked.
And Ms. Siegler's rebuttal testimony and attachments JLS 1R and JLS 2R, filed August 14th, be marked as Exhibit 30.
So marked.
And Your Honor, if there are no objections, I would ask that Exhibit 29 and Exhibit 30 be admitted into the record.
Exhibit 30 is admitted, or 29 and 30 are both admitted.
Next, I would ask that the direct testimony of Kevin Johnson, filed May 15th, be marked as Exhibit 31.
So marked.
And Your Honor, if there are no objections, I would ask that Columbia Exhibit 31 be admitted into the record.
Columbia Exhibit 31 is admitted.
Next, I would ask that the direct testimony of Mohamedou Bikienga, filed May 15th, be marked as Exhibit 32.
So marked.
Your Honor, if there are no objections, I would ask that Columbia Exhibit 32 be admitted into the record.
Exhibit 32 is admitted.
Thank you. Next, I would ask that the direct testimony of Melissa J. Bell and corresponding attachments MJB 1 through MJB 5, filed May 15th, be marked as Exhibit 33.
So marked.
I would ask that supplemental attachments MJB 1 through MJB 3, filed July 1st, be marked as Exhibit 33S.
So marked.
And I would ask that the rebuttal testimony of Melissa J. Bell with corresponding attachments MJB 1R through MJB 7R, filed August 14th, be marked as Exhibit 34.
So marked.
And Your Honor, if there are no objections, I would ask that Columbia Exhibits 33, 33S, and 34 be admitted into the record.
Columbia Exhibits 33, 33S, and 34 are admitted into the record.
Thank you. Next, I would ask that the direct testimony of Mel Kosanovich and attachment MK1 filed May 15th be marked as Exhibit 35.
So marked.
In the rebuttal testimony of Mel Kosanovich and corresponding attachments MK1R through MK4R filed August 14th be marked as Exhibit 36.
So marked.
And Your Honor, if there are no objections, I would ask that Columbia Exhibits 35 and 36 be admitted into the record.
Columbia Exhibits 35 and 36 are admitted into the record.
And lastly, Your Honor, I would ask that the updated website and social media notices filed on July 10th, as well as the proof of publications of the virtual public comment hearing that was filed September 2nd, 2020, be marked as Exhibit B.
So marked.
And Your Honor, if there are no objections, I would ask that Columbia Exhibit B be admitted into the record.
Hearing no objections, Columbia Exhibit B is admitted into the record. I did want to discuss, though, your notices that were what you filed on September 2nd. The notice that was published in the paper is extremely small. And what I'd like to do is next year, we need to do better. We need to address this. Columbia needs to address a way to not make this so small. Okay, so if it's me or if it's another judge, I would appreciate if you make note of it and address this at the pre-hearing conference about how the notices could perhaps be a little more eye-catching and larger.
Yes, Your Honor, we will take that back. Thank you.
Okay, is that the end of Columbia's exhibits?
That is the end for me. Mr. Collins, I just want to make sure you don't have anything else.
Thank you, Megan. Your Honor, we do have a number of company witnesses who are still on the call, and I know that Mr. Tubbs will be available throughout these proceedings. Would you wish for the other Columbia employees who are on this call to remain on, or may they be excused?
I'm just checking the questions that I have remaining. I would hope that I have no further questions for them. To the extent something arises, perhaps we can do it in the form of a written question that gets answered, and then we have the 18th again to clear up anything that's outstanding. But I don't believe at this point that I'll have additional questions for the witnesses that are here today. So if you'd like them to be excused, they may be.
Yes, we would ask for that, and thank you for that consideration. And yes, we will have written responses. We certainly will make every effort to respond to those timely, and we'll also hold the hearing on the 18th in reserve for any other cleanup or open issues for you if you have them to address as well. So thank you. Your Honor, in addition, we are still working on some of the questions that we have not responded to yet. And I think we'll have the ability to respond to them later today, perhaps at the end of either staff or People's Counsel's presentations of their witnesses and testimony. So with your permission, we would still like to respond today. Counsel will do so at the appropriate time later.
That sounds fine.
Thank
you. I'm just going to wait a minute while they all leave the meeting, those who plan to leave. Okay, Mr. Wilson, if you could unmute yourself.
Yes, Your Honor.
Do you have exhibits that you would like to get entered into the record at this time?
Yes, I do. I see Mr. Alexander is waving his hand. Should we address?
Mr. Alexander knows how to unmute himself. We'll give him a second.
Okay, Your Honor,
Yes, sir.
because you've just asked staff, based on our letter, notwithstanding anything we said on our letter, we are prepared and would like to put on our 4 witnesses for your questions and to introduce their testimony, because this seems to be the opportunity now to do so. So if you would kindly, and we want staff as usual to go last after us. So if you would kindly allow us to do that.
Well, Mr. Alexander, I will allow OPC to do as Columbia did, to both offer witnesses, enter exhibits, and offer a proffer on the settlement. But because of your letter, staff will be proceeding next. Then you'll get your chance after staff.
That's fine, Your Honor. Just want to make
Thank
sure
you.
we have the chance. I appreciate it.
You will have the chance, but you will go
Okay.
after staff.
That's not a problem. Thank you, Your
Thanks.
Honor.
Your Honor, staff is ready to proceed. If I might make a suggestion that might speed things up a little bit, I had intended, because our testimony, I believe all the parties will stipulate to its admission, is just to get all of our testimony admitted, and that way we can make the witnesses available to you in any order you want to call them. And
That's fine.
I just think it'll, okay, great. So staff would ask the following testimonies be marked for identification. The testimony of Afton Howard, direct and exhibits dated are filed on July 24th as staff 1. Please mark the testimony of Carlos Acosta, dated July 24, direct and exhibits as staff 2.
So marked.
The testimony of Drew McCullough, the direct and exhibits dated July 24th as staff 3.
So marked.
The rebuttal testimony of Mr. McCullough dated August 14th with exhibits as staff 4.
So marked.
The direct testimony of Felix Patterson dated July 24th with exhibits as staff 5.
So marked.
The rebuttal of Mr. Patterson dated August 14th with exhibits as staff 6.
So marked.
The direct testimony of Mark Riley dated July 24th with exhibits as staff 7.
So marked.
The direct testimony of Olivia Kuykendall dated July 24th with exhibits as staff 8.
So marked.
And Ms. Kuykendall's rebuttal testimony dated August 14th as staff 9.
So marked.
And Ms. Yulia Proboreski's direct testimony dated July 24th with exhibits as staff 10.
So marked.
And her rebuttal testimony dated August 14th with exhibits as staff 11.
So marked.
I would ask that staff 1 through staff 11 be admitted into the record.
Are there any objections to staff's exhibits 1 through 11 being admitted into the record? Hearing no objection, staff exhibits 1 through 11 will be admitted.
Your Honor, with that, we're prepared for you to name those of our witnesses that you indicated you would like to speak to in your email, and I believe they're here for you. We have Mr. John Clementson, the Assistant Director of the Engineering Department Division to take the place of Carlos Acosta, who, as you know, is attending a family member's funeral today and tomorrow.
What about Ms. Poboreski? Is someone adopting her testimony?
No, she is still with us, although she won't be with us very long, and we're very sorry to see her go. She is available for you to speak with.
Okay. If she is, Ms. Poboreski?
Good morning, Your Honor. I'm here.
Good morning. Can you please raise your right hand? Do you swear or affirm under penalties of perjury the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. I'm also it was very sad to learn that you are leaving us. In your rebuttal, you testified that staff recommends that Columbia be authorized to file revised tariff pages that provide the company an opportunity to collect an additional $3.37 million in annual revenues. Staff's recommended revenue requirement is based on an adjusted rate base of $156,000, adjusted operating income of $8.8 million, and a 7.16 rate of return. Staff made an adjustment to.
Your Honor, I'm getting a big echo.
Yeah, I muted you. That should take care of part of the problem. Mr. Wilson, you're now muted too. Okay, everyone is muted except for me. And even the witness is muted. So, okay. Staff made an adjustment to net operating income related to rate case expenses, correct? Now you need to unmute yourself.
Correct, Your Honor.
And that was reflected in Exhibit AID4.
Let me confirm. I think it would be 5, but I'm looking at it right now. 1 second, please. It would be in Mr. Riley's testimony, but I have it in front of me. 1 second.
Oh, excellent. Yes. Staff Exhibit 7.
The rate case expenses is rebuttal. Sorry, my mistakes. We did not provide the exhibits in rebuttal phase. As we thought, we will update them all in rebuttal. But since that was not filed, the latest exhibit that you should have is in his direct testimony, and it should be Exhibit AID5.
Okay. And so rate case expenses would have been reflected in staff's recommended revenue requirement at that point, correct?
Yes.
And what was the recommendation, if you know, with regard to when the amortization of those expenses would begin?
I would believe that it would be together with the revenue when the authorized revenue requirement goes into effect. Please keep in mind that the actual amount of rate case expenses that was presented today by the company is already included in the term sheet recommended revenue requirement of $3.3 million. I just wanted to be clear that you know that.
Yes.
It's regardless
I would
of the
hope so.
amount. Yep.
What's the reason for calling out, since it is included in the $3.3 million in the term sheet, what's the point of, in your opinion, of having Mr. Newcomb supply updated figures at this point?
I guess since the term sheet does state that we would include actual rate case expenses rather than originally, if you notice the company proposed the inclusion of 140 or similar amount as estimated rate case expenses. So it's important for us as a staff to know that only actual supported by invoices and receipts, rate case expenses would be included in the rates, not the estimated amount that was originally thought by the company. I would say that that's the importance of that, but other than that, and also we would like to see the support for those actual amounts that were mentioned today, just to review and make sure that everything is being supported for actual rate case expenses. But again, other than that, it's already incorporated in the 3.3 million.
Okay, and then the only thing that would not be included in the 3.3 million would be, as Mr. Newcomb referred to, expenses incurred. I believe he said after the date that the formal settlement agreement is signed, anything they might incur, and I don't know what that would be, but anything after that they would, I guess, seek to recover in their next rate case. Is that your understanding?
Yes, it will be reviewed and fall in the next rate case. Mm-hmm.
You also took Mr. Patterson's depreciation expense and made an adjustment that was reflected in staff's recommended revenue requirement, correct?
Correct.
And if you know, was that based on staff's recommended ROR of 7.16%?
That's right.
Does the authorized return on equity or overall rate of return impact AFUDC?
One second, please. Yes, there is an impact since AFUDC is part of operating income adjustments.
Would you say that the impact is significant?
No, the impact is through the revenue requirement, not through the rate base. Can you repeat your question again? I want to understand.
Sure. If the authorized return on equity and then therefore the overall rate of return is higher or lower, I was wondering what impact that has on AFUDC.
The AFUDC is adjustment as part of operating income. So again, it would affect the revenue requirement. I would not say that it's a material adjustment to the total revenue requirement, but the ROR is calculated based on the rate base. So in that regard, it would not have any effect on the rate base itself.
Just the ROE, but not a significant impact.
No, it's immaterial adjustment. Again, and it flows through the revenue requirement.
In your direct testimony, which is staff exhibit 10, exhibit AID2, you included $96,513 for cloud-based assets, correct?
Yes.
Staff didn't oppose this amount being included in rate base or the treatment?
No, no.
And then you didn't make an adjustment to operating revenue related to operational order charges, did you?
We accepted the Columbia's adjustment. It means that 202,000 and some change has been removed from the revenues that was originally proposed by the company.
And then you worked with that already being removed, correct?
Correct.
Do you know, similar to the impact on AFUDC, the impact of using an ROE of 9.6 in the company's stride proceeding as opposed to a lower ROE?
Well, stride investments do get included in the total rate base. Of course, the ROR and ROE will affect the amount calculated based on the total rate base.
Is that a potentially significant impact?
It depends on the total amount included. I would say that, yes.
Okay, Mr. Wilson, that's all I have for Ms. Poboreski.
Your Honor, one thing. OPC and myself personally would be remiss if we also didn't wish Ms. Poboreski well. We have all appreciated on behalf of her work has also benefited our clients because she is so diligent and knowledgeable and so thorough in her work. And we can only wish her the best in her move. We will miss her, but we want, if it makes her happy, that's the most important part. So, Yulia, go with, just don't go. But I hope everything is as you would like and imagine. Thank you so much. Thank you.
But if it's not, come back.
Yes.
Thank you. I was happy to hear how. I hope I'll be back. Thank you so much, Mr. Alexander and Your Honor. Thank you. I appreciate it.
Your Honor, you may call whatever witness you wish at this point.
Mr. Patterson. Do you need me to unmute you, Mr. Patterson?
Do you hear me?
I can hear you now.
Okay.
Can you raise your right hand, please?
Yes.
Do you swear or affirm under penalties of perjury that testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. In your direct testimony, which is Staff Exhibit 5, and I'm just going to mute you while I ask the question because we're getting some feedback, okay?
Okay.
In your direct testimony at page 6, you testified that you changed the survivor curve for count 376 for mains from 62-R2 back to 65-R1.5, which changed the composite remaining life from 51.8 years to 55.1 years. The term sheet that's been discussed in this case in the depreciation section states that depreciation rates by gas plan account will be those presented by the company in its direct testimony in case number 9644, revised to reflect the use of the SFAS 143 method for net salvage and applying a 6.1 discount rate, and are set forth in Appendix C here too. So my question, Mr. Patterson, is going forward, will the survivor curve for account 376 mains be 62-R2?
Well, I wasn't part of negotiations for the settlement. It's my understanding that it'll be that way for, well, they're not supposed to change going into the next rate case.
But they changed it in this case. Do you know? And I don't want you to answer if you don't know, but they changed it in this case, and so is staff accepting the change made in this case, or is it going back to how it was before this case?
Well, I'm probably going to have to refer that to staff attorney.
Okay.
Your Honor, I can answer that. It will be using the account and method that for this case, the one that was proposed by the company and by OPC.
Okay, so the survivor curve for count 376 mains will be 62-R2, if I understand that Mr. Patterson's proposal correctly, that is not going to become part of the settlement. Is that right?
I think that's correct, Your Honor.
Okay. Back to you, Mr. Patterson. You calculated, with regard to net salvage costs, the present value of removal costs based on a discount rate of 7.16%, correct? I'm sorry, you were muted if you answered.
That's correct.
And that was based on staff's proposed ROR, correct?
That is correct.
Did you review witness Spanhouse's testimony in this case?
Yes, I did.
And do you recall his testimony that if Mr. Patterson's intent were to actually use a credit-adjusted risk-free rate, he should use a rate of 3.6%?
Yes, I do.
In your opinion, is 3.6% the appropriate discount factor consistent with a credit-adjusted return in this case?
No, it is not.
Okay, would the credit-adjusted return in this case be another value?
Well, our credit adjusted rate, what we're looking at would be the 7.16. Authorized rate of return for the discount rate.
Okay, what is a credit-adjusted return?
We're saying that the credit adjusted return would be the 7.16. I know there's a 6.1 that's in there. That's a negotiated rate. My understanding, that's a negotiated credit adjustment rate of return risk-free rate.
Thank you, Mr. Wilson.
Yes, Your Honor.
The next questions I have would be for staff witness McAuliffe.
Mr. McAuliffe, would you join us, please?
I see his name. There he is.
Good afternoon.
Good afternoon, Mr. McAuliffe. Can you raise your right hand, please? Do you swear or affirm under penalties of perjury the testimony you're about to give in this proceeding is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. In your direct testimony at page 12, which that's page 12 of Staff Exhibit 3, you testified that in developing my recommended ROE, I also considered the financial market effects attributed to COVID-19. You also noted that the downturn in the market has created a lot of noise, which you have in quotes, that makes it difficult to determine a company's ROE. Does the downturn in the market related to COVID-19 result in models predicting a higher or lower ROE?
Because COVID-19 quite substantially, all betas have increased. I put in my testimony. So it's hard to price the first gas ROE I've done. The cases I've done substantially. The issue is, for example, with the DCF price fluctuations are so drastic in March, they can really kind of throw off. For example, and if the opportunity to say adjust their, so therefore that increases their dividend yield, which may lead to a higher ROE, for example, in the DCF model. But at this time, I don't know that we could exactly say what effect on the models there would be. So like I said, for the CAPM, there's kind of competing changes in the model. Risk-free is dropping, while the beta is increasing, so they almost can cancel each other out depending on the numbers. So I would say it's hard to say if it's just up or down.
The company witness, Mr. Reya, stated that interest rates continue to be artificially influenced by interventions by the Federal Reserve. Do you agree that if the Fed was not intervening, interest rates would be higher?
I don't necessarily agree. I don't agree with his phrasing either, that they're artificially. I mean, the Fed took the action that it did. So we're in the market that we are. It's hard to say what would have happened without that intervention. But the fact is they made that intervention, which has decreased interest rates, which was their goal. So I'm not sure we can say exactly what would have happened. Would they have been higher? Again, it's a hypothetical situation. I don't really like to guess at what would have happened. But the fact is that they did what they did, which, as many people have stated, has stabilized the economy largely.
Do you know, or does anyone hypothesize when the Fed might stop intervening?
I mean, that's a good question. I know, for example, the federal funds rate is the one interest rate the Fed really controls directly. They have said they're going to keep it 0 to at least 2022, the 0 to 0.25 basis point range, which is the lowest they can do. They haven't really speculated going into negative rates with some countries in Europe, and I believe Japan does as well. But they have stated at least that rate that they do directly control, they would like to keep in that range until at least 2022.
In your testimony, you referred to the impact of the COVID-19 pandemic as a short but drastic downturn and also a short-term market disruption. Sitting here today, would you still characterize the economic impacts of COVID-19 as a short-term market disruption?
So in the market, I would say yes. You can see in just the stock market valuations, all of the indices, major indices, the Dow, the S&P 500, and the Nasdaq were all at year-to-date highs and above, and had a positive return year-to-date. As of I believe a few days ago, there was a bit of a downturn earlier in this week. But so I was referring more to the markets. They have definitely recovered, as I just stated, with their returns year-to-date. And I believe the Nasdaq is even 16% above for year-to-date. It had quite a large run there. So for the market, yes, again, I would say it is recovered, but as we've heard earlier, the unemployment rate is still 8.5%. So it's kind of a different consideration though when we're considering just the markets themselves.
Do the other items other than the market that you just referenced have an effect on authorized rate of ROEs around the country?
So again, that's a good question. I've tried to do some research into what other commissions are saying. I mean, a commission could definitely weigh the impacts of an increased ROE would have rates. Obviously, the higher ROE, the higher ROR, or the higher rates. So a commission could definitely take that into account and say, obviously a lot of customers are hurting right now. We don't believe an ROE of say 10% is equitable to the utility and the customers. So in my analysis, we try to balance that, but we really don't have any kind of data to back that up. So the commission could definitely take that into account if they wish to do so.
Thank you. Mr. Wilson, your co-counsel is waving at you, I believe.
I don't know who he's waving at.
Maybe he's waving at a friend. I mean, I don't know. I just see him waving.
Yeah, I think we should just proceed.
Ignore him? Okay.
Yes.
I unmuted you, Mr. Albert.
Thank you, Your Honor. I think before we proceed, just a clarification. We introduced Mr. McAuliffe's rebuttal testimony as Staff Exhibit 4. Mr. McAuliffe did not file rebuttal testimony.
That may be correct, Your Honor. I made a last-minute change, so we can just ignore Staff Exhibit 4, as there is one.
I'm looking at the docket item number 22. Rebuttal was filed. Mr. Patterson, Ms. Kirkendall, Ms. Pogoretsky. I don't see. I believe Mr. Albert is correct that Mr. McAuliffe did not file rebuttal testimony.
I think you're right. I think I confused it with the Sir rebuttal that he had prepared and ready to go. So
okay, hang on.
I apologize for that.
That's fine. Mr. McAuliffe?
Yes.
Is that correct? You didn't prepare rebuttal. You prepared Sir rebuttal?
That's correct.
That was never filed. That was never filed. Do you intend to file it?
I do not believe so.
Okay. All right, so just to correct the record, there is no Staff Exhibit 4. We will just skip that number and all the other numbers will remain the same. Staff Witness Hauer.
She's unmuted.
Ms. Hauer? There you are. Hello. Can you raise your right hand, please? Do you swear or affirm under penalties of perjury that testimony you're about to give in this proceeding will be the truth, the whole truth, and nothing but the truth? We can't hear you, though. We can't hear you. Okay, you know what? While you try to fix your technical issues, I think we'll move on to a different witness, Mr. Olson. Why don't we move on to Mr. Clementson, if he's available? Mr. Clementson, are you still with us?
I'm here. No camera.
That's okay. Do you swear or affirm under penalties of perjury the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Did you review Mr. Acosta's testimony in this case?
Yes, I did.
He testified that with respect to the cross-bore program, the early identification of the cross-bores will aid the company in preventing damage to its pipelines and minimize the risk to people and property. Therefore, I support the initiative. Do you also support Columbia's cross-bore initiative?
Yes.
Do you understand the testimony earlier today distinguishing between the amount the company spent during the test year on this initiative and the amount that it refers to related to acceleration of that initiative?
I believe I do.
Okay, could you care to elaborate?
From what I understand, they spent, I guess, $87,000, which is going into the rate case, and then they have $75,000 in future costs that they're looking at also.
Okay, and do you understand why that's an acceleration?
Let me get to it if you give me 1 second.
Yeah, take your time.
I believe testimony, at least Mr. Acosta's testimony, does not explain the acceleration part, so I can't really answer that as far as that goes.
Okay, you testified that you support the initiative. So does that mean that I believe it's $81,071 that's currently in the company's cost of service, you agree that that's a prudent expense that should be included in the cost of service in this case?
Yes.
Okay. Do you express any opinion with regard to the additional up to $75,000 that apparently is going to be spent in the future?
No, I don't.
Would you like to see or need to see information about that amount in order to determine if it's prudent?
Give me 1 second here.
I guess I'm not even certain. Do you typically review a cost that's going to be spent in the future to determine if it's prudent?
Typically, yes, we have on certain things, and specifically like stride and such. I mean, part of the settlement was the company's going to provide a report to show what is found out, in regards to this, how it's performing, how many they looked at, how many they found. I mean, it's a worthwhile endeavor for safety, because these things do happen, and they can result in, explosions and, I hate to say it, deaths.
Okay, but it's your understanding the $75,000 hasn't been spent yet.
Correct.
And you would want to see information in order to determine if that amount is prudent. Is that also correct? I don't want to put words
Yes, I
in.
mean, that would be they would basically report on, how many they looked at and the results of that. How many they found that were actually cross bores.
Okay.
That wouldn't help determine the prudency of this.
Mr. Acosta also testified that the usage of a new technology from the Picaro platform to perform leakage surveys over the mains is very important in order to maintain the safety of the company's distribution system. I therefore support the company's proposed plans. What do you know about the Picaro platform leak survey system?
Okay. A little bit of system started around in basically 2012 is when they came about. They've been used for 8 years. The equipment is about 1,000 times more sensitive than traditional leak survey equipment, which means basically that you will find leaks or gas concentrations at a much smaller amount than the traditional equipment would. Therefore, you would be able to find a leak faster or sooner potentially than you would with standard equipment, therefore making it an improvement as far as in the process for leak survey.
Okay, you said it's been around since 2012. You don't mean Columbia's been using it since 2012, do you?
No. Just the Picaro equipment itself by the manufacturer. To my knowledge, this is Columbia's first attempt at using it in Maryland that I'm aware of.
Okay, and they're proposing to begin that in 2021, correct?
Correct.
Do you know why not until 2021? Are they purchasing it, renting it?
I am not sure on that one.
Thank you, Mr. Clementson. Mr. Wilson, do you know if Ms. Hauer was able to fix her technology issues?
I don't.
Can you guys hear me?
Yes.
There we are.
Okay, sorry. I had to switch out headphones. The other one's a little bit older and sometimes doesn't work, so my apologies.
That's fine. Let me just get back to my questions. In your direct testimony, which is...
I'm sorry, do I need to be sworn in again since...
No, you're still under oath.
Okay.
Did you... Well, I said the
I said yes.
Thank you. Okay. In your direct testimony, which is Staff Exhibit 1, you stated that the effect of the proposed operational order charge revenue tariff revisions on customer bills was not clear. Did you review Ms. Hassan's rebuttal?
Yes, I did.
At page 7, she testified that the operational order revenue of $202,992 occurred between November 2017 and March 2020. So do you understand the company's proposal to be that they will credit this amount of revenue that occurred between November 2017 and March 2020 through the ACA?
Yes.
And then on pages 9 and I think on to 10, Ms. Hassan shows some rate impacts that reflect only a portion of that amount, I guess the portion of the operational order revenue that occurred from November 18 through October 2019. Is that how you understand Ms. Hassan's testimony?
That was on page 9, you said?
Yes, of her rebuttal.
Yes, that was for the ACA period.
Okay. And she only put a portion of the total amount in her analysis, correct?
Yes.
Do you agree with her testimony that sales service customers benefit most when the operational order revenue is applied to the ACA?
Yes.
Would they not benefit if the full amount of the operational order revenue of $202,992 that occurred between November 2017 and March 2020 was credited in the next ACA that commences on December 2020?
I believe that sales service customers would also benefit if the operational order charges revenue was put back into rate base. However, also benefiting would be transportation customers that caused the operational orders and were billed the operational orders revenue.
Yeah, not back into rate base. What I'm asking is the proposal is that the 202,000 be divided into 3 payments over 3 years. What I'm asking is if the full amount of the 202,000 were credited in this upcoming ACA in December, would sales service customers not still benefit?
Yes, they would benefit.
The bill impact based on your proposed rate design was approximately 8% for the average retail customer, correct?
Yes, 7.9%.
And as part of that, you recommended an approximate 4% increase in the fixed customer charge. That's currently $15.40, correct?
Yes.
So if the provision in the term sheet that only increases the fixed customer charge from $15.40 to $15.70 is accepted, that'll be I believe about approximately a 2% increase. That'll be much smaller than you recommended, correct?
Yes.
Okay, Mr. Wilson, that's all I have for this witness.
Thank you, Your Honor.
And I don't believe I have any other questions for any other staff witnesses.
I think that exhausts all the staff that are here with us. So,
do you have any other things you'd like to add at this point? Any other?
I do not. That would conclude staff's case.
Okay. I would note for the record, and you can disagree with me if you'd like, Mr. Wilson, that the term sheet that company witness Tubbs testified about was also all the terms therein were agreed to by staff, correct?
They absolutely were, Your Honor.
Thank you. Okay, at this point, what I propose is that we take a half-hour break for lunch and that we come back at 1 o'clock. Does that work for everyone? Okay. See everyone at 1 o'clock. Thank you. I'll start the meeting back up shortly before that.
Thank you.
Thanks.